My name's Jaime Levine. I'm the Executive Director of Elder Law and Advocacy. Today we are chatting with attorney Caleb Logan, who's an attorney with this organization, about legislation that was enacted in 2025 that affects our clients and community. Caleb, thank you for joining me. Would you like to start with a little bit of background about the work you do with legislation and the organization's involvement with the California Low Income Consumer Coalition?
Thank you for having me. I'm happy to be here to discuss this as we head into 2026. So, as you mentioned, I'm an attorney here. I have in the past, actually, I started here as an intern in 2019. And back then, one of the things that really excited me about elder law and advocacy was its participation in the California Low Income Consumer Coalition, CLIC, and discussing through that lens what laws could be passed in California to make life better for consumers. And for our clients, of course, being older adults, realistically, anything that protects low-income consumers will also be protecting older adults because they are consumers just like anyone else, and in fact have additional vulnerabilities that I think since joining elder law as an attorney, we've been able to push with CLIC more of an elder justice lens and focus on laws that will better the lives for low-income older adults and older adults more generally. And so I believe it was at the end of 2022, we had actually gotten involved with proposing a law that would have revamped the elder financial abuse statute and imposed some additional obligations on financial institutions with regards to catching scams. That bill, after a 2-year effort, was ultimately vetoed, and we then came back last year with another bill focused on scams and protecting older adults in those situations. That was stalled in the committee. Essentially, there were two competing bills. So there was our bill as well as another bill proposed by another assembly member. And so the Assembly Banking and Finance Committee decided to just turn it into a 2-year process again, like the last bill that we were working on. And then this year, hopefully, we will be reconciling differences and hopefully getting some meaningful change out there through CLIC, and that remains to be seen. It's still early days.
Yeah, that's a very important initiative, that legislative initiative that you're discussing. But we should recognize that legislation in California, when it comes to elder abuse and seniors in general, is actually pretty strong. Can you just say something about what we have existing on the books?
Right. The main law in this area is the Elder Abuse Independent Adult Civil Protection Act. That's the law that defines the statutory term elder. So generally, we say older adults now. The law at the time uses the term elder and defines that as a California resident who is aged 65 or older. And so its protections apply to those who are 65 and up. And then it defines financial abuse as part of that and says that financial abuse occurs when someone essentially takes or hides or steals a older adult's property wrongfully or with intent to defraud. It can also apply when someone helps someone else to do that, or when someone takes property using undue influence.
Right. And in those cases, there's sometimes elevated damages available, or attorney's fees, and or sometimes a different standard, lower standard may be required in order to prove abuse, things like that.
Right, one of the bills that we'll get into in just a bit was regarding the ability to recover attorney fees in physical abuse cases. That is actually a higher standard than what's required for recovering attorney fees in financial abuse cases. So as long as you prove financial abuse more likely than not happened, the attorney filing the case can recover their attorney fees and court costs, any costs of a conservatorship as well, things like that.
Well, since you brought it up, why don't we discuss that? I think that was, is that
AB 251?
AB 251. Yes. What is AB 251? Tell us about that.
Yes, this was a bill brought by or authored by Assemblymember Kalra. I believe actually that our friends at the California Advocates for Nursing Home Reform, Canner, were the brains behind this bill. It had been a multi-year effort. This year it did pass, and so it is now law officially. And so I mentioned the distinction between physical abuse and financial abuse cases, and what the law generally requires is that to recover attorney fees and costs for physical abuse, you need to show not only that it was more likely than not that physical abuse happened, but actually that there is clear and convincing evidence that it happened. And if you think of the different standards of proof that we have in the law, most people are most likely familiar with the beyond a reasonable doubt standard that we have in criminal law, so a very exacting standard. Below that, we have clear and convincing evidence, which means that something basically there's substantial likelihood that it happened. Below that, we have our normal civil standard of proof, which is a preponderance of the evidence, and that's the more likely than not standard that I've been referencing. You just need to prove that something, again, more likely than not happened, some level above 50%. So this means that it's much harder to get attorney fees in physical abuse cases because you have to show that clear and convincing evidence, as well as showing that the defendant acted recklessly, which the law also defines different levels of culpability. And you can think of it on a scale of the bottom being a negligence standard, as that, and some people have a colloquial understanding of negligence, basically that someone had a duty to do something and failed to comply with it. Recklessness would be a level above that, so it's raising the standard, not just the standard of proof, but actually what you're required to prove in the first place. So with this bill, AB 251, it reduces the standard of proof from clear and convincing evidence to a preponderance of the evidence in cases of what the law calls spoliation of evidence. So if the plaintiff is able to show that the defendant, usually a nursing home, that's why a canner would have been involved in this. So if the plaintiff shows the defendant actively concealed or obstructed or even destroyed evidence, then the standard of proof gets lowered so that you're dealing with that more likely than not standard to recover attorney fees.
Okay. And that's so having a lower standard and also not requiring recklessness, that's something that makes it easier for individuals to file claims?
Yes, it will make it easier. I would have to double check. I don't believe that the bill did anything to address the recklessness standard.
Oh, okay.
But so even though that would still be there, it's much easier to show it.
Right.
And oftentimes these are situations where a nursing home knows its obligations. Like, let's say someone develops a bed sore that gets infected and ultimately leads to a stage 4 ulcer that causes them to die. The nursing home knows that they need to be rotating the person, if they're immobile, every 2 hours. It should be fairly easy to show that they recklessly did not if their own logs show, well, no staff came in every 2 hours to actually rotate them, or no staff, once the wound appeared, tried to address it properly, things like that.
So just to clarify, recklessness in the situation that you're describing, that'd be a situation where they've documented that they've seen that there's this issue and then they ignore it. That would be probably reckless. Whereas if they just didn't attend to the resident and just never saw that it was there, that would probably be closer to negligence?
It just depends on what exactly the awareness of the risk was. So with negligence, we're dealing with whether the law actually requires someone to do something or not. With recklessness, it's generally phrased as something like the person being aware of a particularly high risk and just willfully disregarding it.
I see. Okay. Uh, let's talk about AB 561. And yeah, what is AB 561 and what was your involvement with AB 561?
Right. This was actually a bill that we got involved in after a conversation with the executive director of the City of San Diego's Family Justice Center, Diane Doherty. So she had been involved in an effort, I believe it was 2 years ago, that amended the rules as applies to domestic violence restraining orders. And I brought up that I was a little frustrated because the law for elder abuse restraining orders was still more limited, and the bill that was worked on for the domestic violence context was never extended beyond that. And so she actually, said that that's a great point. We should, work on that. And so I had been working, I basically drafted what ended up becoming AB 561, presented that to her, and she got the city attorney's office involved because they have their own legislative process and presenting bills to the state legislature, things like that. Then through Click, I heard that another organization who's part of Click, Betsetic in Los Angeles, had found basically that they had encountered the same issues that I had. And with them, so we got them involved, and then we also got Justice and Aging involved. And Justice and Aging really, I think they kind of helped coordinate the effort a little bit, identified an author for this bill, and ultimately it got passed in would have been September, I believe.
So that's that, and it basically establishes that these filings can be done online. Is that what this legislation is about?
Yes, so some courts, like the San Diego Superior Court, say that you are not allowed to file elder abuse restraining orders online at all, which is kind of odd because attorneys are legally required to e-file all other documents. So it seems like an unnecessary impediment, especially when you encounter older adults who might have mobility issues. If they're filing on their own, they often can't go to the court. They might have, in addition to mobility issues, transportation issues, whether they're able to actually drive or not. And so it seemed like an unnecessary impediment, and one that is especially unnecessary given how common e-filing is. So, as you say, the bill allows for e-filing and make sure that that process is free. Another thing we've seen is that although the petitions requesting an elder abuse restraining order are by law supposed to be filed for free, why I wanted to make sure that there was no change to that with e-filing was that we've seen courts increasingly add what I would kind of pejoratively term as junk fees. So they're charging these like a technology access fee or another service fee, whatever they want to call it. There's no regulation as to how much that fee is. There's no regulation as to whether they can charge it in the first place or not. They just do. And so I wanted to make sure that it is specified in the law that no, e-filing needs to be free so that these people can access the court system when they need to. Because even if it's only $5, that can definitely add up for an organization like us who we have e-filed for clients in the past. And for people who are living day to day on a fixed income, a few dollars can make all the difference.
Absolutely. You don't always get credit for having drafted AB 561. I just want to make it clear that you did draft that bill.
Thank you. Well, and we definitely had a lot of good input from, like I said, the folks at Bethedic, Justice and Aging, and there was a whole process working with the Judicial Council to get this law passed, just to make sure that it was in a form that they approved of. And that's actually why the law will, even though it was passed last year and signed by the governor, it will officially take effect in 2027.
Okay. Yeah, it was definitely a joint effort. But I'm just bringing it up because a number of times we've received correspondence from others about this bill, and they've given credit to some other people, and you haven't been mentioned. So I wanted to make sure that you were mentioned.
Well, thank you.
Let's move on to, let's go to the big one. H.R. 1, the Budget Reconciliation Act of 2025, sometimes referred to as the big, beautiful bill. And there have been a number of, that was actually a very encompassing bill. So there are a number of issues that have been addressed that affect our clients. Why don't you go through some of those?
Right. A lot of people will probably think of it as a tax act, but it does much more than that. So the tax aspect was largely making permanent the aspects of I believe it was 2017's Tax Cuts and Jobs Act that was passed under the first Trump administration. So making those things permanent, but then also adding other elements. So the Securities and Exchange Commission, which regulates things like stocks and other securities, as its name implies, they had in 2010 been given what was basically like a savings account called the SEC Reserve Fund. And they had been using that money, I believe it was about $5 million when this bill was passed. And they had been using it to upgrade critical IT infrastructure. So what H.R. 1 did was actually eliminate that funding completely. So it could prove detrimental to any of our clients, especially older adults who are more likely to have investments and be subject to whether it's investment fraud or other wrongdoing in the area. By hampering the SEC's processes, it could hurt investors in the future. Just kind of one of those things that remains to be seen how it plays out in practice. Mm-hmm. Another issue is with the Consumer Financial Protection Bureau, which is an administrative agency that oversees people like mortgage lenders. It was created after the 2008 financial crisis with all the predatory lending that went on with home mortgages. And so it actually took over some regulations from the Federal Trade Commission, the FTC, as well as implementing other laws that were created at that time in 2010 when it was created. So it has a unique funding structure, and essentially it's funded by transfers from the Federal Reserve's Board of Governors. Those transfers are based off of a percentage of the Federal Reserve's operating expenses, and that percentage had been set at 12%. So H.R. 1 reduced that to 6.5%, which means that this agency, which actually does focus specifically on older adults in many areas, will have less funding to do what it does and protect them from industries that are taking advantage of older adults and essentially, not complying with the law. Because if there's no one enforcing the law, then there really is no need for them to comply with it. Mm-hmm. Another aspect of this gets into more of that tax aspect that I was mentioning earlier. For older adults, there is a new $6,000 personal exemption. So this means that everyone who is aged 65 and up can claim a deduction of $6,000. This is beyond the standard deduction. That's why it's referred to as an exemption. It's not part of the standard deduction. And it does phase out for single filers who make over $75,000. For joint filers, it starts to phase out at $150,000, so just double the $75,000. It is a pretty slow phase out and doesn't drop to zero until someone is making $175,000. So it should be widely available to older adults no matter how much they're making. And again, they're generally living on a fixed income and probably don't have realistically $75,000 of income. Another tax aspect is a tripling of the estate tax exemption. So the exemption was $5 million. Now it was increased to $15 million by H.R. 1. And for spouses, that means that there's about $30 million in assets that you can pass along when you die. And that's a pretty big number. I would be surprised if even 1% of our clients have that much to pass on. So for most older adults, it will basically mean that when you pass, there will be no estate tax implications from that. And then last item that I want to highlight is restructuring of Medicaid. As part of that restructuring, there was a Department of Health and Human Services rule passed in 2024 that requires minimum staffing requirements for nursing homes. In other words, the nursing homes were federally required to have a certain number of staff each day. So the law here pauses all enforcement of it, pauses all, of the rule even taking effect. And that is likely also to be formally abolished because the Department of Health and Human Services published just recently an interim final rule to get rid of the rules, regardless of what Congress is saying about, well, you can't enforce it. This is the agency itself formally saying that it's no longer the rule in the first place.
But California still has minimum staffing laws.
Yes, that is the case. And actually, one area of interest on this is that Canner, which I mentioned earlier, they had worked on a bill last year that would have imposed minimum staffing requirements on residential care facilities for the elderly, RCFEs as they're known, and that it got held in committee in the first house of the legislature and unfortunately was not passed. So I hope that they come back and keep trying with that.
Yeah, that's great. That's I think the minimum staffing law was introduced by Tony Chicotel. Before he was at California Advocates for Nursing Home Reform.
Oh, wow.
A long time ago. Yeah.
That's great. Yeah. And he might be the brains behind the RCFE law as well.
Very likely. Yes. Tony's amazing. Let's move on to the Delete Act.
Yes, so this was actually a law passed in 2023. It was authored by Senator Becker, and Click was a supporter of this law. We weren't a sponsor, but when someone else sponsored it, we decided to support it. The reason being that it allows the California Privacy Protection Agency, which was created after voters passed Prop 24 in 2020, allows this agency to regulate data brokers and also requires the agency to actually implement a platform that allows consumers to basically have a route or a means of communication to the data brokers directly saying, this is my data, I want you to delete all the data associated with me that you have. Mm-hmm. And the rollout of that platform happened, the deadline by the law was January 1st, 2026. So California now has that platform out in the world. The data brokers will start processing requests submitted to that tool in August. So if you do it right now, it won't be immediate that they are processing it, but definitely I would encourage everyone to do it as soon as possible if you would like to decrease the amount of data on you that's out there. And especially, I think today there's still the conversation ongoing about whose property your online data is. And so this tool gives you a measure of control over that and says that the data brokers can't profit off of the content that you yourself are generating through your data.
That's great. What is a data broker?
Ooh, that's a hard question. I would have to, I don't want to say anything that's, because the law actually defines what a data broker is, okay. And that defines who the privacy protection agency can regulate. But essentially, the data brokers are entities that buy and sell consumer data. That data is being generated online, and there's a huge proliferation of data realistically, because every time you visit a website, the website can see exactly where you're clicking, where sometimes if you got to that website by a different one beforehand, it'll actually tell you what that site was that brought you there. It knows your operating system. It knows what browser you're using. It knows your IP address, unless you're using a virtual private network or VPN. It knows your screen size. So there's a lot of data out there that people just don't realize, as well as data like the social media account information that Facebook or Instagram collects, or Twitter, X, whatever,
Yeah.
whatever you use. So
And this is the URL. I'll say what the URL is, and we should put it up on the screen as well. It's https://consumer.drop.privacy.ca.gov. And so what happens when you go there? Is there a list of data brokers and you can see if you have data? How does that work?
no, you actually don't need to go through and choose which data brokers
Oh.
have your data at all. What it does is allow you basically click a button and say that you want to use the tool. The tool is called Drop. That's why it's in the URL. And at that point, you're able to input information like email addresses, zip codes that you've lived at, your car's VIN. Also, TVs and mobile devices have unique IDs that advertisers use to track them. So that's another thing that can be sold by data brokers. You can input those on the tool, and essentially what it does is just have that one size fits all platform. So that request to delete your data will go out to everyone regulated by the industry, and they'll have to process that, identify what data they have of yours, and then delete it.
Right. Okay. And so, but I mean, we should differentiate between these legitimate companies that have your data and the ones on the dark web who have the data that they've stolen through hacks. And we've all been subject to those. And there are a lot of websites where you can see if your data is on the dark web. And unfortunately, all of our data is. So this has definitely some utility in terms of making it possible for you to eliminate your data in some ways. But all of our data is out there somewhere, unfortunately.
Yes, but there's at least some measure of control now.
Right, exactly. And I think the final bill we are discussing today is AB 656.
Yes, this was a bill brought by Assemblymember Schiavo, who I think she's done really quite a lot of good work in the consumer protection area. And so I think most older adults today typically use Facebook as their preferred form of social media. I don't mean to say that as a generalization. It's just what seems to be borne out by the data. And so this bill that did become law, it applies to social media platforms like Facebook with over $100 million in yearly gross revenues. And it requires them to have basically a button that is clearly displayed and allows people to delete their account. The situation was actually somewhat comical because I'm not sure if it was in the Senate or the Assembly where the person writing up the report. So when a bill gets sent to the legislature, each committee hearing the bill will write a report about it, and let's say like what the law is right now, what it will be as a result of this bill, any arguments for or against. And so this committee report actually gave screenshots of someone trying to delete their Facebook account and how difficult it was. And it's something that I experienced when I deleted my Facebook account. I could not figure out how to do it myself. I had to look up how to do it and then go through multiple hoops to actually delete it. So this bill is designed to stop that. And again, going back to that some measure of control over our data, this will allow people to more easily delete what is out there about them.
That's great. All right. Well, that is, I think that's all the bills we were going to. Oh, wait, one more bill. We didn't
Yes.
discuss the Inflation Reduction Act.
Right. So this was actually a bill passed in 2022. It's a federal law that was passed under the Biden administration as President Biden's kind of key legislative achievement, just like as it's called, the One Big Beautiful Bill is kind of President Trump's key legislative achievement of this administration. And so, what the Inflation Reduction Act did was allow Medicare to negotiate drug prices with the private companies that are making them. And unfortunately, it didn't take effect until this year. But with that being said, now there are going to be 10 drugs with lower prices as negotiated by the government. And so that should result in savings to the government itself and also hopefully savings for the consumer.
Great. That's a step in the right direction, although 10 seems to be a very low number.
I was thinking that myself, and I can't name the 10 off the top of my head. It's available online if anyone's interested in looking into it more. But hopefully we'll get much more than 10 in the future.
Yeah, hopefully. All right. Well, thank you very much, Caleb. I appreciate you chatting with me about legislation of 2025, and we will definitely follow up on this in the future.
Absolutely. There will definitely be more to come.
Thank you.